Ladies and gentlemen, we are live again with another one. We got exclusive content here, man. This is the Young Thug, Gunna, and 14 others in court live. Rico hearing again. We are live again with Showface. Make sure you smash that like button, man. You can call me what you want. Just don't call me woke. We here, man. We are here. We are here.
My best friend Stephen Rosenwasser says very nice.
Not related to me.
Not related to you.
No relation.
Oh yeah, we're they just gave us. Oh well. My law clerk who's running around.
We are here. We are here. We are here.
Yeah.
All right.
Like we waiting, man. We are waiting. Very, surprising news.
I'm just going to recess everybody, so you don't need to get queued up. I'm going to recess everybody for about 45 minutes. So just whoever needs to come back in, I've got a civil counter I got to take up. So just give me a second.
Shall we, you want us to clear out? Here?
No. I'm going to do it chance.
Okay, all right. Can I ask a question of the court?
Yeah.
Mr. Williams, I give you my word, this happened. I know Mr. Adams was next to me. He asked if he could be out of the room and not come back. Mr. Adams told him that we have one more issue dealing with Mr. Stillwell. Conflict, and he said he waived his presence. He knows he has a right to be here. And that did happen. I don't know if it's recorded somewhere, but that did happen. You go back.
Okay. I mean, I don't have any issue you waiving his presence for the remainder of
just for today.
For today.
Yeah,
that's
not for
right.
anything.
All right. Councils, I just want to put something on record right quick. I have some civil hearings I need to take care of. In fact, you'll probably see me in just a minute on the same Zoom information. I'm going to take care of those matters just briefly. I should be back with you about 1:45. So at least give you an opportunity to take comfort and lay the vending machines or do something that will at least provide you a little bit of comfort or food dependency. My plan is to come back in the courtroom after that time and finish up our business for today. Dealing with several emotions to include the severance issues. So I'll take that up today. All right?
Your Honor?
Yeah.
I am scheduled to argue motions in another case in Douglas County. Would it be okay for Mr. Adams? He said he would remain.
That's between you, Mr. Adams, and your client, Mr. Williams.
Thank you, sir.
Okay? All right. We're in recess until 1:45. Yeah, you're welcome to use the tables. That's fine. Don't be in my. I'm going to do the other civil hearing remotely, so you're welcome.
Thank you.
I need it.
Jeffrey, can you hear us?
Smash that like button. Whoa, y'all black screening us? Y'all better fix them. Y'all better fix those cameras. Y'all better fix those cameras and get right. Why did y'all black screen them, man? Make sure y'all smash that like button. We here, man. Showface news with the exclusive. As always, y'all know I bring that exclusive. You know what I'm saying? We gotta keep that exclusive. You dig? But we in here, man. Make sure y'all get them likes up.
Hold on. Before you go on recess.
Come get me. Yes, it is. So I'm just going to take front hand on the face. Let's see right here. I'll try to come get you.
Okay. But when they can get you, you can go. Okay.
Yeah.
And the judge is going for the next 45 minutes anyway.
You know,
Everything okay over there?
Sorry.
We have
Okay, if your family was concerned that something was going on, you're fine, right?
Yes, I'm great.
Okay, cool.
those happy locks.
Well, me when he asked you about that British song. Those are better, don't you think?
Yeah, this
I'm just party. Never again.
That's just the
And
breaks down questioning.
I'll see you later, Jeffrey.
Then suddenly broke down and confessed to the murder of his wife, but confronted with a damaging in his marriage. That's his dad's handwriting. He took it back and tried to divorce him so he could marry another woman. They also spoke for a growing fear that he was planning to kill her. How awful it must be for a wife to suspect their husband's planning to kill her.
Sounds up.
Why do you hate me, Laura? Huh? Ralph Harrison's love for you is what caused Edith's death. But why blame me? I certainly did nothing to encourage Ralph while she was still alive. You didn't waste any time after she was gone. So why should I? I was tired of fighting.
You ain't missing. Y'all ain't missing. Okay. Wow. Goodbye. Young thugs, dreads, mighty stack. Dogs, dreads, very, very aggressive.
thank you. All right, you're welcome. You're welcome.
And I know a lot of people. That's probably a lot of yeah, this is Rico.
Bye, you guys. Have a nice day.
All right, too.
Yes, yeah, they had the early reset, like on
well-known architect.
Hey, Chris.
in the meantime,
How much was that?
but they
Okay,
like
sorry. Feel better. All right, what's up, buddy?
they'll get to like in a crazy week. I didn't expect this, usually when they do, not, it's usually because it's usually we don't expect it to happen. That's what ends up happening. Starting. wrap up this is actually life in prison after being indicted first. You already I know that.
Hi, good afternoon, everyone. I'm just here for my civil calendar.
Well, I don't know who money.
All right, Sullivan versus Sullivan and Randy Wise and Steady Beer Company. Just give me a minute, 1 second. I'll be with you all in a second. Did you all want to have your matter taken down?
Yes, please, Your Honor.
Okay, all right, just give me a second. All right, position number 2 is Woody versus Malcolm McKay, Mercedes-Benz, Mercedes Financial.
David Turner for defendants, Judge.
Okay, you all have an announcement, as I understand it, from that case, parties.
There was one guy pretty far, one of those special
Mr. Woogie, did you tell Mr. Kearns you were going to dismiss your motion?
Correct.
Judge, she doesn't have a pending motion. She has attempted to file a dismissal, I think, of the case without prejudice, and I object to that. We have a pending counterclaim, or at least Mercedes-Benz Financial does. And so we want to move forward.
Okay, just give me 1 second.
We don't know what this. I don't even know what this hearing is about. They just had motion hearing. And we get a Rico. We don't know what this is about. Honestly, y'all, this just started. I think we haven't even it's started. Started. This is a little weaker before they start the trial. Make sure you smash that like stuff. We didn't even begin yet. They haven't even started. They ain't even yet. Not yet. Nothing started yet now.
Yeah.
All right.
Yeah.
Live and direct. Whenever they ready, I'm good.
Mr. Turner, I think that Ms. Agagi, she can dismiss over your objection. I know you want to go forward for obvious reasons, but I think she in terms of voluntary dismissal, she can go ahead and voluntarily dismiss.
Well, I think as it relates to the counterclaim, which we have, Mercedes-Benz Financial has a counterclaim.
But can your counterclaim stand independently? Plus, there's been no motion for, she just filed a voluntary dismissal. And you can file one up and before the first witness is sworn.
I understand, but there's also law when there's a pending counterclaim, you can't unilaterally dismiss.
Well, unless your counterclaim can stand on its own, and I believe it can stand on its own, can it?
Yes, sir, and I've got a motion for summary judgment that's ripe for ruling on the counterclaim. That's the purpose of the hearing today. I filed 2 motions for summary judgment, one on behalf of all defendants as the plaintiff's claim, and a motion for summary judgment on the counterclaim. There's been no response within the time limit. Nobody requested a hearing. I assume the court wanted to hear argument today, and that's what we're.
I do. All right, I'll tell you what. I'll give you 15 minutes. So that's usually my customary practice. So you can tell me why I should grant your motion.
Very good. Thank you.
All right, your time's running.
Oh, you want me to start now? Okay.
Yes, sir. Yes, sir.
So, assuming you're going to permit her to dismiss the claims against all the defendants without prejudice, is that my understanding?
Yes, sir. I would.
Okay. I will just say I think that's problematic because she may refile these claims, and we've spent a tremendous amount of time and effort preparing the record and so on, and filing a dispositive motion, which is meritorious. And so for her to file a dismissal minutes before this oral argument, it is, frustrating the process and driving up our expenses, which may be their intention, but I don't think it's appropriate. As it relates to the counterclaim, Mercedes-Benz Financial Services is one of the defendants. And their counterclaim is for lease ending charges for a motor vehicle, amount of $18,161. The plaintiff did not oppose the motion for summary judgment, and it's based on a vehicle that she leased in 2016 and turned in 2019 with excess mileage of about 55,000 miles. And
I've read all that. I'm more interested in the statute of frauds issue.
Okay, well, the statute of frauds goes to the merits of the claim she's dismissing. So if you want to hear about that, I'm happy to tell you about it. But that goes back to the motion for summary judgment by all defendants on the plaintiff's. And so she's dismissing all those and is being permitted to do that.
Well, if I allow her to do it, but if I don't, what would be the issue of the statute of frauds?
Well, she's alleging breach of an oral contract to pay off her debt owed to Mercedes-Benz Financial Services. And that type of agreement has to be in writing and charged by the party with enforcement to be enforceable. In other words, she has to have a writing signed by Mercedes-Benz and Buckhead saying they're going to pay off her lease termination charges owed to Mercedes-Benz Financial. And there is no writing of any kind to memorialize that alleged agreement. The salesman on the deal was Mr. Malcolm Mackey, who's on the call today. He signed an affidavit saying he did not make any oral agreement with her that the dealership would pay off her lease termination charges. And none of the lease documents make reference to that type of agreement. In fact, we produced a copy of the form from the plaintiff's deal file. It's called Payoff and Tag, is the title of this document. But it's what they use when a payoff is part of the deal. And the document in plaintiff's file has handwriting where they crossed out the payoff part to indicate there's no payoff agreement, and the plaintiff signed off on that document. Then we get to the issue of the merger clause. The lease has a merger clause, the 2019 lease, saying the written agreement is the entire agreement of parties.
Yeah, I think her argument is that, you know, she said had some oral agreement saying that the $15,000 was supposed to be forgiven or not collected, but the court would agree with you that that would need to be provided. The merger clause certainly, that didn't affect it, certainly affected as well. So.
Yeah, so that's the merit of those claims. And she also had alleged a tort claim for fraud, but that's going to be barred by the merger clause because she affirmed the 2019 lease. She took the vehicle, she's been driving it for 3 years. I mean, that lease is about to end. They're 36-month leases. So she affirmed it, the agreement with the merger clause, so she can't sue for fraud. So that's why her claims for fraud are barred, excuse me. We also have another argument, lack of justifiable reliance. It's kind of a cumulative argument. If you agree with the merits of the statute of frauds argument and the merger clause as it relates to the fraud claim, you wouldn't reach this. But, you know, she's got a duty to read the contract, read the agreements, and there's nothing in there about paying off her termination charge. So that's the argument on her claims. We also filed for summary judgment for the termination charges owed to Mercedes-Benz Financial Services. She sued them. She's never paid them since 2019. And we included an affidavit and so on from Mercedes-Benz Financial that she owes an excess mileage charge, a turn-in fee, a wear and tear charge. The total of that's $18,161.65. And we've got an affidavit indicating that's owed. Plaintiff hasn't disputed it. Her argument was that the dealership agreed to pay it for her, but of course the dealership and Mercedes-Benz Financial are separate entities. So the evidence affirmatively shows that Mercedes-Benz Financial is entitled to judgment on that counterclaim for that liquidated amount. So those are our motions, Judge.
While this going on, nigga, I'm about to upload the TikTok, nigga. Man, y'all follow my TikTok at Showface News, y'all. How many y'all niggas actually got TikTok? Oh Lord, this is crazy. I got the wrong. Hold on, man. Let me just make sure I got the right stuff up here, cause this looks insane. This looks insane. Hold on a second. Jesus Christ, this is the wrong shit. Let me fix this. I got the wrong tags in here. Like, what are we doing? What is this? You gotta fix these. You gotta fix these. Cause why in the world would this be up here? I gotta fix something real quick. That's insane. That doesn't make any sense at all. Hold on, man. We're gonna have to make it make sense. There we go. That works. That makes a lot more sense. Okay. Good job. Make sure y'all smashing that like button, y'all. We still waiting as we proceed. I guess last time people made a noise complaint because if they actually played sound before the court hearing, it was a lot of distortion that was being played. I guess that's why they're not trying to do it now. I guess that's a good reason for it, right? I guess it makes sense. Whew. Mm-mm-mm. Uh-oh. It look like they coming back, y'all. I think it's time to get right, man. Make sure y'all get them likes up respectfully. Let's get these likes up, y'all. Man, when these niggas coming back? Jesus Christ, nigga. Nigga, I'll be here all day. Nigga, I'm about to order DoorDash. Y'all niggas keep playing, man. Fuck is niggas talking about? Nigga, I'll eat. I will eat on this live. Y'all niggas got nigga, we just letting it sit just like this, you heard? We gonna let this thing sit, pause. Word to my mother. You know these things last long, man. These things go for a little bit. Boy, oh boy. Make sure y'all smash that like button at least. Come on, guys. Niggas is playing, boy. Hey. First and foremost, I already know it's in recess. That's number one. I've been saying that since we started. I said that they just went to recess. That's literally what I said when this thing started. You dig? I've already said that, champ. All right. So we already knew that already. You know what I'm saying? Mm. Man, they already said it was in recess when it started. You know what I'm saying? But yeah, damn. So somebody wants to be very insane right now in the chat. I'm gonna get you. I'm gonna get you right. Don't worry, champ. You could take time. You can take time. Thanks, champ. The things that people do for attention. So we chilling, and yeah, somebody has to come in on some weird stuff. Now you could very much be a child, or you can be a grown up that lives with their grandmother. Either way, you know what I'm saying, we gonna see what happens, man. Mm, mm, mm. I know niggas ain't saying rest in peace, Queen Elizabeth, but I'm gonna keep my thoughts to myself respectfully. Come on, bro. You gotta do better. Queen Elizabeth. Nigga, do you know Queen Elizabeth, nigga? I don't think so. Mm-mm-mm.
I mean, that's the choice of attractive. That wasn't the main concept.
Yeah.
She's supposed to be considered.
Huey. Kendrick, do not leave out the booth, okay?
Yes, ma'am.
Marquavius Huey. Hey, just be patient. Don't leave out the booth, okay? The judge will be with you shortly. A few more minutes. Thank you.
How did you wait 30 minutes to tell me that you didn't have a TikTok? That's a little wait. You went back on the live and I said I'm about to upload a TikTok to you
What?
to tell me you didn't have a TikTok. It is what it is, Chief. gotta make these take time. These gonna have to take time. Ah, hey, respectfully, I have no comment on the death of Queen Elizabeth. Hey, my response is niggas die every day, B. Respectfully. Shall we begin? That's my response, man. You dig? That's my response. You feel me? It is what it is, champs. Can't live forever. Sometimes, you know, things happen. Hey, niggas die every day, respectfully. Want to put that on a t-shirt. Mm-mm-mm. Hey, this is a live stream, just so y'all know. Uh, everything is live. I don't record. I don't. Yeah, this is live. Just so y'all know. Also, I don't care what Queen Elizabeth did or what she owns. It means nothing to me. You know, this ain't a study class or nothing like that. People just want to watch. You know, they want to see the stream. They want to see what's going on with this YSL thing because this is kind of like the first of its kind where people are seeing rappers get indicted and seeing them. They got to get sentenced in January, but this is the first time people are really seeing rappers collectively get locked up in mass like this. So they interested in seeing it. You know what I'm saying? This ain't that, y'all. But this is a live hearing. Like I said, we're waiting for them to get off recess. They at recess right now. And after they get off recess, they'll be continuing with this Young Thug and Gunna situation. They said this is a Rico hearing. That's what I heard, you know. So I'm assuming, you know what I mean? I'm assuming. You dig? That maybe they're gonna get they're trying to get out on bond too today. I'm sure they're gonna try to make them get bond today, but we know they're not gonna make bond. They can't make bond. This is too serious, too high level. It's a Rico. You know what I'm saying? So that's gonna be hard to do. That's gonna be very hard to do. I ain't gonna hold you. You know what I mean? We gonna see. We gonna see about that bond situation. I ain't gonna hold you. That bond situation is a different type of topic. I'm not gonna lie. Nobody's look. Let me tell you something. Ain't nobody going home. Nobody. Nobody's going home. Nobody's going home. This is serious. Nobody's going home. They be lucky. They be lucky to get a sentence that involves them ever making it out of there alive. They'll be lucky if they could live after they sentence. Because 9 times out of 10, 10 times out of 10, they're going to get hit with an incredible life sentence. You know what I'm saying? They going to make an example now. Franny, what's her name? Franny Willis, right? The DA of Fulton County. She said that she's strictly going after all the rappers. She's strictly going after all the rappers. Now, whether or not these rappers are committing crimes or not, she said it's their lyrics, and they're coming after the lyrics because the lyrics is what is, the lyrics is what's making, them go after the rappers because they're admitting to crime and things like that, which is understandable because if you're admitting to crime, then obviously you're going to lead the police to look at you, right? But it's weird because that's the main focus, you know. And yes, these rappers is definitely terrorizing full whole, they definitely terrorizing areas and whatnot and doing too much and extorting other artists and things like that, which is bad. It's not good. But all of a sudden this year, y'all wanted to do this. I mean, like I said, we expect people who are criminals to get locked up when they do admit their crimes to masses of numbers of people. You know what I mean? But at the same time, it's like they just chose this time to do that. You know what I mean? But you shouldn't trust nobody like that. We still don't ride. I don't ride with no police or nothing like that because some people still not to be trusted because just like Young Thug and them is criminals, them people is also criminals too themselves to a certain degree. You know what I'm saying? Don't ever trust no DA or nothing like that. We don't trust those people. Them people move very shiesty. Those people are snakes too. We should never trust them. You understand? Don't think just because they doing what's right by law that it means that okay, these people are good people. That doesn't mean that they're good people, bro. Because these people protect all types of other people who do crimes as well. You understand? So yeah, man. I wouldn't say, oh, this person is doing God's work or something. They're really not. Respectfully. Oh, it looked like it's about that time, champs. It looks like it's about that time, champs. People out here talking about how, the DA is the best. She's making change. She's amazing. Ooh, the DA. Get out of here, nigga. If you don't sit down, champ, respectfully, if you don't sit down, nigga, you're gonna have to get right. You're gonna have to get right. Let me tell you, I know Gunna's a good rapper and all that. I know Thug is a great artist and a legend and all that. But sorry, champs, this is what happens, man. Unfortunately, they started flexing. You dig? So yeah, y'all. I know how this is gonna go down, but it seems as though they're about to get started soon. You know what I'm saying, so we're gonna see what happens.
So does that make you dexterous? Did you go up there?
Boy, oh boy.
Smells good. Why did you put it there? Why are you gonna put it there? I didn't know where you guys were. But yeah. Like I love it. Like better. Hi there.
I assume it was sharp. It's a beautiful day.
It's from here. It's a little changing for me sometimes. You know, if you're slower than me, you look at, I'm probably gonna time you. That's how I mean, hopefully we can do where they are.
Man. These boys is not coming home, and if they are, it's no time soon, y'all. I'm gonna tell y'all that right now, respectfully. And I know y'all niggas ain't just zoom in on a piece of tissue now, did you? I know y'all ain't just zoom in on a box of Kleenex right there. Y'all gonna have to get right. Come on, cameraman, what are we doing? Let's get right. Come on, man. The nigga just gonna point his lens to tissue. Like, come on, bro. It looked like tissue, champ.
I mean, what's there will not be a 76. No, there will not.
Yeah. No, you guys are more than.
years? 75, she had her 75th jubilee. 70.
Yeah, she was really.
75th.
It's such an impressive life course. I mean, that's amazing. We went this summer. We saw the Queen's jewels.
Really?
Oh, yes.
I'm a little crown. Crown is on Netflix.
Oh, the crown.
You know, all
I
the
have to
watching
join in.
Oh, that's a good show.
No, I followed Kate's firm. That's about it. Yes.
Charles is the king.
Camilla. Charles is the king, but he's gonna advocate to.
No,
not.
I don't think so.
You think he's gonna take it?
Yeah.
Yes. Really?
Yeah.
I would.
Right.
Are you kidding? Really? Oh, I thought he just did
Does he have a
this.
wife? Yeah, no one. Oh my gosh. you're
That's
right.
really
So she's.
I really thought he was just gonna pass and like Harry.
Would be that.
Oh, you have to look.
I
No,
really
that's
thought,
okay.
I don't know, I don't know. So basically, he's a figurehead, we got the after work, so like, obviously.
It's hard work.
So it's just hard, right? This is hard.
I never
I'll keep you for kids.
We
The
need
whole
to go
time.
somewhere. And it's taken like,
I'm king for a day. First person on my side.
That's not nice. Bring it, brother, bring it.
Bring that diamond.
Here's the young fella.
If you want-
Wait, there is always
It's
one
amazing
thing.
that folks are so
Well,
American,
he's the
so
one
into
that's
the
in
whole women.
Take time, champ, respectfully.
And then after William, his eldest son. Right.
I don't like when people come in there and catch being extra. That's how you get bold. We don't do that. You're doing too much, champ. You're gonna have to take time. What are you even doing? Relax. I know you want attention, but no, champ, respectfully.
And the rest of them are screaming, hooting, hollering.
I have seen it.
It's like, it's grossly disrespectful.
I asked them.
You sit there and someone's talking and someone goes, "Hey," and everyone goes, "Shit." That's the normal course. Everyone's doing it.
That would be.
No fire. Well, it's a constitutional law. So, well,
I bet that's gonna be quite a funeral.
Oh my
God.
Well,
be on the news, not stuff.
Oh, yeah. Well, she was, I say is, was the longest serving, wasn't she?
Oh, yeah.
I think so.
Well, it should have to be, she's what? I mean, like, nobody lived to 96, like 100. That's what it says, the longest. living.
Yeah. And she became queen so young.
I'm surprised at my English.
Is it, did the judge say when he was coming back? Do I need to get Jay back in here?
Yeah, he came out, but then he went back for a second.
I think Jay went to get a snack. My question is, do I need to text him and be like, get your butt back here?
I mean, I think he's on his way out.
All right, Charles. I'll put a crown on.
His sister don't
They
get
get
that.
to pick a new name when they become king, right?
They do.
Yeah. They get to pick a new name if they want. They asked Elizabeth when she became
The
queen.
boy told her, man, listen, tell him like this.
I would say, is her name like regularly?
She kept her own name, but they didn't always keep her own name.
Oh, I think they're.
They usually change this.
Well, they all have like a bunch of names anyway.
I know, right?
The
It's like a Dostoevsky novel.
I mean, Elizabeth.
I really know.
Really?
Maybe walk.
You can only know. Maybe Audrey or. I quit once a day.
When you're king.
I like the landscape. I'd rather do that than
Hey, you never know what's coming, bro.
I know.
You know, you gotta be ready.
Gotta be ready to
Every
take
ranger has a like any time.
Let me see.
Yeah, just a chance.
Are you this merchant?
I am.
Okay, and then, the two standing behind Mr. Adams. I'm not sure.
Miss Ingrid.
I'm Doug Weinstein.
All right, who do you guys say?
Mr. Kendrick.
Both of you do?
Yes.
Okay.
Oh, with Mr. Adams?
Yes.
Oh, man.
Oh, okay, so give me your names again, I'm sorry, because I just got Mr. Adams.
You go ahead, Katie, you go.
You're-
K-A-T-I-E, last name H-I-N as in new, G-E-R-T-Y.
And then.
And I'm Douglas, Douglas. Weinstein, Weinstein. Sure.
I see people really hate Young Thug and Gunna. Y'all niggas want to see these niggas buried, nigga. Y'all want to see them niggas meet the dirt now. Hey, look, I ain't mad at you, champs, but yeah, man.
We would have like.
No, don't you hate when? I hate on trials. I love being on trial. I hate.
You love being a child still.
I love it.
Yeah, like this. That is really cute.
Yes, that's without doubt. But,
Do they care?
the part I hate is when we have to
Do
play
they like
together.
having a
You know, we got to sit there and wait for that jury.
As long as we
I
have.
God, that drives me crazy.
As long as.
Not used to it by now?
No, they say, you know, well, go get something done. No, that's not happening.
Well, they shouldn't offer, like, we're stuck somewhere else, we can't, we have 5 minutes away from the courtroom, the family's all up in our junk, and it's like, dude, I can't make it happen any faster.
No, the first, from 1989, the first year I haven't tried a case was 2000.
2000 or
2000, no,
2020.
2020 was the first year I didn't try a case since '89. And I've tried to count, and I'm probably about 350. I spent most of my time as a prosecutor, so I mean, many a year is 20 or 25 a year.
What is my bet doing these days? Do you still have-
He's the judge, he just got to
He's
start
just
as a judge.
yeah.
He took Mary Staley's.
No, he took Kells.
Was who?
He took Kells.
Was it Kels?
Yeah, he did not take Sally's.
I thought it was Staley.
He got the good and the bad.
Yeah.
Okay.
Yeah, he took Kells' case.
Yeah. He just got sworn in like a week or two ago.
Okay.
And then they brought in the former police chief, Mike Register, to be the new director of the GDL. Yeah, and then John's still going to stay as the assistant director. There's 2 assistant directors.
I feel like I know Mike Brown. Like, where would I know there?
He was the chief of police of Cobb for years.
Maybe, here you had something up there.
Yeah.
Maybe.
John was in he's still assistant director. There's 2 chiefs, yes.
It's like number you went into the 2.
Number 3, depending on who's telling the story.
Well, when he went over the bit, he was, he went over the bit after a while. Because he stayed, he was the interim DA there for a while. And then I think they appointed another assistant director, who John promoted. And I think it was the other, John was going to move into College, and I think he decided not to move into College. And his father went to.
I went to the second floor, I couldn't find a thing of it. I tried to move this office thing.
The new bench, we're bringing a whole new bench.
Oh, yeah. Big Miss Jill.
Hercules, on the ground.
Yeah. But the guy, his name is his wife's a partner, King Sloan.
He's in the circle.
No, he's.
Was the DA or?
No, he was one of the ADs.
Right, he was on spiritual.
He's now a school court judge. He was, I said, I think he was Florida. Yeah, and then of course Harris, she ran from that office. And then, gosh, the guy that got appointed right after I got there, Henry was to be one of the, state court judges, but the lower level, he just got moved up to Superior Court. Yeah, he got moved up to Superior Court.
Okay, I didn't know that.
Yeah. Let me say that I believe that she is.
Okay, I mean, I remember from the DA's office in state court, nice guy.
Cause I got over there with Vic in January 1st of 13. And Rub started the murder trial on the 14th or something like that. doing an appointed judgeship on the 12th. It was his murder trial. And Grubb said, send me an attorney, I don't care. Just go. So I tried to murder him.
Give me a mic.
You know, because again, okay, I can do it.
Yeah, only still faces all over the place.
I mean, I don't recognize it. And I was up there a year and a half ago doing the things, and I don't recognize it.
Good evening, good evening.
I have about 50 attorneys that I think there's less than 15 that were there. Year and a half ago.
Yeah.
Yeah. When Dana walked out the doors, out of the 50, it was probably 12. I mean, I think he's vice president of city next to me. I still don't know what his title is.
I think he does, we'll have a conviction integrity unit.
Yes.
I think they do it now too. I think that's what her does. Maybe. I don't know, man. I'm trying to cut down. Okay, just get it to us. Trying to get a little run around as possible.
You know, that's when I started people calling me. I'm like, when I just under half of my case, my client for police station. And I was all over this stuff. And I said, I'm sorry. I can't just keep going.
Yeah, I'm referring a lot for a couple different reasons, but the main reason being, well, no, the main reason being I just didn't focus.
Yeah.
But the second biggest reason being is you get older. I'm tired of driving up the south, driving up, you know. And I know you feel it, you know, like I do.
When you were
It lets you know each other.
Okay.
She just lets you know you did not.
That's right, I guess that's the good one. You hurt, you're still alive.
It hurts. You know,
Still alive. Yeah, no, I don't even do anything. Really?
Some occurs in motivational speaker. Is there such a thing as a deep motivation?
Yeah, I don't even touch, you know, well, I don't say I don't touch, I'm bringing things that I have. So I'm turning it off, so they have a little Clayton Douglas, Henry stuff. That's, I'm the cat, maybe Rockdale, like that.
I tried to share, I tried to stay just in time. And I was probably 90% successful.
It's hard because just when you say I'm not going to college anymore, and something comes with just the right inducement.
Yes.
You say, right, I'll take it.
It's just above Tallahassee in Georgia.
Lounge?
You know, it's over on the other side. God, it's kind of, it's the different kind. But it's like, that's kind of guys and the county is 15 bucks. So, and that's like it.
Please, emergency, court of order.
Yeah.
He's in this same dorm. I don't know if he's not coming, but I don't have anything suggested.
Okay, folks, before we get started, we're gonna do, let's see. Computers are still on. Where's Mr. Sharp? Mr. Sharp, we're having, are you ready on that issue?
On the,
Your client,
oh, am I aware of the issue? Yes.
Mr. Stillwell? Yes.
Man,
Yes,
y'all
I'm
want to
aware
start or
of
nah,
the
man? Where's the sound?
My
I
suggestion
know this
is
ain't
that
on closed
maybe we
caption.
table him
Whoa,
for
whoa,
today,
whoa, hold on.
and let's just put him back on for Kearns. I think that we're gonna probably put the ones for the jail back on for the 13th. People in the Department of Corrections custody, I think Mr. Stillwell's in the Fulton County Jail. We're gonna put those people back on. That's my regular assigned day is on the 13th of October. That's the next time we can kind of bring him.
Is the same?
Maybe you can go out and talk to him in person.
I'll definitely.
And save some of his issues and, concerns he might have. Okay?
Yes.
All right. So just want to let you know, that's the only reason that we're we've been waiting. I was going to do him last to see if we can arraign him and take care of the other waiver issue, but we're not going to do that today. That's what the jail staff's telling me, all right?
Okay, Your Honor, and I acknowledge that he is not present. There was one objection that I wanted to put on the record. I can waive his presence of an issue that was discussed today. Would you like me to do that?
What was that in regards to, sir?
It was in regards to the proposed order with the delayed disclosure of cooperating witnesses in their statements to our clients. And just on behalf of Mr. Stillwell, also known as Mr. Jackson, in his absence, I waive his presence for the purpose of making this objection. But we too feel that disallowing the attorneys from discussing the statements of cooperating witnesses until the end of November.
November the 25th.
Right. And with the trial coming up in January 9th, we anticipate that the statements of cooperating witnesses may be the crux of this case, and obviously a lot of the information that is pertinent in drafting a defense and coming up with a defense involves input from our clients.
This is crazy.
So we would also object.
What are we doing?
And of course, we're going to abide by the court's order, but we would object to that delay in being allowed to discuss the evidence against our clients openly.
Refresh. There's no way I just lost sound and all that. That's crazy, bro. I'm gonna just refresh it because that's insane. I don't believe that. Come on, bro. Y'all ain't put no sound on this.
All right, so
I can't hear it. Let me hold on. I think
Mr. Chamberlain, where are you, sir?
Y'all can hear it. Copy. Maybe my headphones is off.
I'm right here, Judge.
Sir, I'm going to put Mr. Stillwell, number 14, on for the 15th of October, okay?
13th, Judge.
13th, you're correct, sir, the 13th.
Yes, okay.
All right, thank you.
You're welcome.
All right.
Young man.
Sure.
That was the only other matter that Mrs. Steele and I had in regards to Mr. Williams. And of course, we waived his presence earlier.
Yes, sir, did you wish to remain, or you're welcome to do so, or would you like for the court to excuse you?
I'm asking for the court to excuse me. I'll probably go back to my office and maybe chime in.
You're welcome to do so. Yes, sir.
All right,
okay, all right. Ms. Sharp, you're excused as well, sir. Thank you. Okay, all right. All right. Okay, Ms. Merchant, thank you to begin with for your patience with us. To begin with, and let me go ahead, and you have several motions, but can I deal with the issues involving the motion to dismiss and plea and bar, and then the double jeopardy issue?
Yes, Judge.
Okay, and then I'll transition into the motion to sever, and I'll let you and the others who are here, who have severance issues they want to talk to me about, go ahead and do that time.
And we are happy to hold on the severance issues. We were given some additional discovery by the state on Friday, which I think bears to the severance issues. It was the discovery for the new indictment. So
Okay.
we've never seen that up until last Friday. I've worked through it, but there's hundreds of hours of videos, and there's been 2 business days this week since I've had it, and I haven't gotten through that. So on the severance,
I will let you defer that until a later time then.
Great.
Okay, all right. But, okay, so let's take up, so we'll table that one, your motion to sever. I'll let the others decide accordingly whether they would like to do so as well. But go ahead and let's talk about your motion to dismiss based on statute limitations and the double jeopardy issue.
and Judge, where would you like me to be to argue?
Any place is fine. You
Okay.
can remain at the table, you can sit down, you can come to the podium, whatever your pleasure.
Thank you. I know that courtroom logistics have changed somewhat.
Yes,
so I
ma'am.
just wanted to ask.
Okay.
Thank you, Judge. So we filed 2 motions. One of them is based on the statute of limitations, and one of them is based on double jeopardy. I filed them under the old indictment, and then there was a new indictment, so that added some other counts. So the argument is somewhat different because of those new counts, but I want to focus on the 2 predicate acts that were alleged in the indictment that we believe are barred by double jeopardy in the statute.
And just to clarify, I did sign an order authorizing the current motions that were filed under the old indictment to be reincorporated in the new indictment ending in 572. So to perfect your motions and argument, we've already, that they will pertain to this indictment. Anything else you add, okay?
Thank you, Judge. So there's really 2 incidents that I want to focus on, and I want to just talk a little bit about the facts first because I think that's helpful. My client was first arrested in a case that is alleged in Act number 11. So in the indictment, the new indictment, it's on page 17. It is Act number 11. It's alleged to have occurred on September 18th of 2014. That count says that as an associate of YSL, he committed a felony and aggravated assault with a deadly weapon against a person named Michael Castellini. And that is an act of racketeering activity and an overt act. So they're alleging that it's an act of racketeering and it's also an overt act. That case, the aggravated assault was dismissed. It was null-prossed. And my client pled guilty to a reckless conduct. He received 12 months probation on that case. That was in.
Okay, all right, go ahead.
That was in 14 SC 131032. And again, the aggravated assault was null-prossed, and he was convicted and adjudicated guilty on lesser included on count 3 of reckless conduct, and received and successfully completed 12 months probation. The firearm charge was also null-prossed. Moving forward, he is charged then on page 22 of the indictment. He's charged in Act number 29, along with a couple other folks. That act is not alleged to have been a crime. That is only alleged to be an overt act. So that's not one of the ones that we're arguing about double jeopardy pertaining to, because that's not actually a crime. But if you fast forward to page 30, acts number 56, 57, 59 are all part of an action that happened on October 1st, 2015. That case was a conspiracy to commit murder, a theft by receiving stolen property, a firearm, and a street gang participation. My client is currently under first offender probation for that case. He was charged by this same district attorney's office, and he was granted a plea bargain under the First Offender Act, and he is still on first offender probation. My client is then charged with another overt act, but that is not alleged to be a crime, on page 40, number 97. Also on page 43, number 111, he's charged with a photo. That's another overt act. Again, not a crime, not a criminal act specifically. And then page 48, he's charged in 131 and 132 with additional overt acts, not crimes, about a YouTube video and a conversation. So those are essentially the crimes that he's charged with up until the May 9th case. The two underlying cases, the 2014 and 2015 case, both of which he pled guilty and was sentenced for, we are alleging one should not be allowed to be used as predicate acts in furtherance of racketeering activity, and two should be barred by the statute of limitations. So it's a little bit, our argument has shifted a little bit because now they have indicted him on additional counts that happened in 2022. So while I will agree that takes the racketeering act outside of the statute of limitations issue, the two predicate acts that they've alleged, the ones that we've outlined, the two I'm talking about, when I'm talking about those, I'm talking about the 2014 and the 2015. Those two crimes, those two cases that he's got probation for. We do not believe that those should be allowed to be charged as predicate acts, and that those should not be allowed to suffice as two of the crimes that have to be proven for a racketeering case. And what he's charged with, if you look back at the statute, Judge, he's charged with 16-14-4. That statute says that it's unlawful to do an act through a pattern of racketeering activity. It says you have to have, and then the definition section of that statute is 16-14-3. It says a pattern of racketeering activity, this is subsection 4A, says engaging in at least two acts of racketeering activity, and that the last of such acts occurred within 4 years. It then goes on under 5A to define what racketeering activity means. And it means to commit any crime which is chargeable by indictment. To commit, solicit, coerce, or intimidate another person to commit a crime which is chargeable by indictment. So essentially what they're doing is they're using two criminal acts, which he has already pled guilty for and was sentenced, and which are also outside of the statute of limitations, as the two predicate acts to bring him under this Rico statute. These are different than the overt acts. There's overt acts that they can still argue these overt acts are somehow relevant, but that's not what our issue is. Our issue is these two criminal acts that happened 9 years ago, 8-9 years ago, for which he has pled guilty and sentenced. And if you think about it, what's going to happen if this is allowed to continue is in front of the jury's going to hear he's pled guilty and was sentenced to these acts and is on probation. So they've already got an admission. He's actually under sentence currently on one of them. And so there's a lot of different case law I did want to address because the state addressed it in their response brief we received yesterday. And I did just want to address briefly, I'm not going to bore the court with double jeopardy case law because I know the court is well aware of what the case law is, but the state had made some contentions in their brief that we had somehow misrepresented what the current state of the law is. Judge, I would just refer the court to the 2021 case of Maxwell versus State. That is probably the most recent double jeopardy case out of our Supreme Court. That case specifically cites the cases that I've cited in our motion.
What's the citation for Maxwell versus?
Yes, Judge. It is 311 Georgia 673, and it was decided June 1st, 2021. And at the time, Chief Justice Melton found it important to cite the same cases that I cited in our motion that the state has said it was improper somehow for me to cite. On page, in that opinion, they cite Estevez, which Estevez was overturned as far as whether we use the required or actual evidence test. Yes, but they cite the exact statement of law that I cited in my argument. And I think that case, that Maxwell case, is really the most instructive. And it talks about procedural double jeopardy and the factors that must be satisfied. The factors that it talks about that must be satisfied are if a second prosecution is barred, if the crimes could have been brought in the first prosecution, that this constitutional double jeopardy protection is enhanced by Georgia's statutory double jeopardy protections, and that we have an additional double jeopardy protection here in the state of Georgia. Unlike constitutional double jeopardy, Georgia's statutory procedural double jeopardy extends the concept of res judicata to the successive prosecution of different crimes arising from the same conduct in situations where the state should have prosecuted the different crimes in a single proceeding. These were all the three things that are required. They were all known by the prosecutor at the time, and they could have been all charged in the same action. So if they had wanted to charge him with conspiracy when they charged him with the 2015 case or 2014 case, they could have. There's no additional discovery on those crimes. There's no additional information that wasn't known to them then. And so, Judge, it's just our argument that that they're outside of the statute of limitations and that they should be barred by double jeopardy. Thank you.
Okay, thank you. All right, which one of you all is going to argue that? Mr. Floyd?
I'm up, Your Honor.
Okay.
So, a couple of things. For this to make sense, I have to start by untangling what's just been said. Problem number one is that under count one and the analysis of the elements you've just been given, counsel's looking at the wrong part of the statute. She mentioned 1614.4. There are 3 violations listed under that. Sub A and sub B are substantive. They each require as an element a pattern of racketeering activity. The argument you heard about how there has to be a pattern of racketeering activity, you heard the definition of racketeering activity out of 1614.3 sub 4A, I believe it is, doesn't apply. This case is under 1614.4C, a conspiracy case. The counsel acknowledged that it's a conspiracy charge, but then kept citing the elements of the different subsections of it. Okay, a conspiracy does not require proof of a pattern of racketeering activity. That is absolutely clear. When you read the text of the statute, which says, while A says there must be a pattern of racketeering activity, conducting or participating in an enterprise through a pattern of racketeering activity, B says obtaining control or an interest in an enterprise, real property, or personal property through a pattern of racketeering activity. C does not use the phrase pattern of racketeering activity. It says there must be an overt act, and that overt act must be by any member of the conspiracy. It does not have to be by a specific defendant. So in this case, there is no requirement of any overt act by Mr. Arnold. It can be by any of the others. And that is Pasha versus State, which we cited in the brief we filed with you yesterday, Your Honor. And so I don't fully understand why we were talking about pattern just a minute ago, but it didn't need to be talked about at all because it simply doesn't apply. As counsel acknowledged, a conspiracy case can be based on one overt act by any one of the defendants. Again, that's Pasha. So it doesn't, much of this argument, it seems to me, is just largely misplaced. It doesn't matter to the survival of count one whether a particular act occurred more than 5 years before the indictment, and I'm going to switch to statute of limitations in a second. And it doesn't matter whether it's an act of racketeering activity or not, so long as it is an overt act. There are 191 overt acts alleged in this case. There are over 140 that occurred within 5 years of the filing of the return of the indictment. And there are, I believe, 3 against Mr. Arnold that occurred in May of this year. So as to the count itself, there is absolutely no question that it is timely.
Well, I think that what her argument is that in these particular counts, They're outside the statute limitations.
Okay, and that's the next thing I'm going to turn to.
I mean, she's right. I mean, she didn't argue the overt acts. She didn't argue anything else. She's just saying that these particular acts that happened in 2014 and 15 are beyond the statute and may fall into the issue of double jeopardy.
Okay, so let's break that down because it is two separate arguments, and I'll address both of them for you, Your Honor. As to 1614.4, my point was, as to Mr. Arnold, just reading the wrong parts of the statute, focusing in on specific predicate acts for a minute. There, it's misreading the statute of limitations, which is a different provision. That's 1614.8. 1614.8 is quite clear, and it says that the statute of limitations begins to run 5 years after the conduct in violation of a provision of this chapter terminates. That's not 5 years after a particular act of racketeering activity or 5 years after a particular overt act. It's after the conduct in violation of the provision terminates. In the context of criminal law, criminal cases under Georgia Rico, that means the last overt act or the last predicate act is how you measure the statute of limitations. You did not measure it based on the first act, be it an act of racketeering activity or an overt act. You don't measure it on any intermediate act. You measure it by the end. And that's Conzo versus State, which we cited in our brief, and Watley versus State, which we cited in our brief. And just to be clear on that, that means you measure it from the last overt act by any conspirator. So there is no basis whatsoever in the criminal cases in Georgia law to strike or eliminate or dismiss or whatever it is Mr. Arnold's actually asking to do. The word dismiss was used. You don't dismiss individual predicate acts. You dismiss counts. The count is absolutely timely. If less than 3 months ran between the last overt act alleged in this indictment and the return of the indictment.
What about our argument in terms of double jeopardy?
Okay, the argument in terms of double jeopardy is a little different, and it takes a moment to explain. And we again filed a separate brief on that yesterday. So Rico is a somewhat different kind of animal. And the case that Arnold originally relied upon was a case called Martin versus State. That was a case out of DeKalb County. And in that case, DeKalb indicted 2 Rico counts, substantive, and then every act of racketeering activity was separately charged as an individual freestanding count. Defendants were convicted across the board of everything. They appealed, and using the rule that then existed, which was under a case called Estevez, State versus Estevez, and another case called State versus Haynes. The Court of Appeals looked at the situation and said, number one, we recognize that our rule is different. The federal rule is different. And it looked at a case called United States versus Phillips in the 11th Circuit. Phillips applies, and there's a lot of cases in this chain, Phillips applies a case called Blockberger, a United States Supreme Court case from 1932. Blockberger says to determine whether 2 acts are the same offense, you look at the elements. And if each has an element, the other one doesn't, they're 2 separate crimes, can be convicted. I'm sure you've seen Blockberger in the past in other contexts.
Yeah, I remember from law school.
Okay, well, and
then some.
Right,
so.
right. And yes, it is kind of hoary old law, right? And so Phillips was an 11th Circuit case that looked at that in a RICO context and said, yes, defendant, you could be convicted of both the underlying act of racketeering activity and of a RICO violation. Martin looked at that and said, yes, we acknowledge the federal law and we acknowledge it's governed by Blockberger, but we have Estevez and Haynes, and they announced a different rule. And Estevez and Haynes said, if the elements, you're barred if the elements are the same or if the evidence is the same. And this was the old concept of the state, quote unquote, using up its evidence on one count so it couldn't be used on another. That's what led to the reversal in Martin. Right? Martin, if I remember right, is a 1988 case, I believe. It's prior to 1990. So there Martin sits until along comes Drinkard. Drinkard is a unanimous Georgia Delta Romeo India November Kilo Alpha Romeo Delta.
You got that, Christina? Okay, all right, okay.
Think the word drink with ARD at the end maybe makes it easier. I'm sorry. And so the Drinkard comes along, looks at State versus Estevez and says, that's a bad case. That's a bad rule. That's not our law. It never should have been our law. And expressly adopts Blockberger. And that's in 2006. Why is that important? Because both before and after 2006, the federal courts had been applying Blockberger in their RICO cases all along, right? And the federal courts had, not surprisingly, every combination of double jeopardy argument you can think of, right? And so these included the defendant has previously been convicted of an act of racketeering activity, and the government indicts and alleges that as a predicate act or an overt act. That's what's happened here. Okay. Or he's charged separately with the underlying predicate acts and a RICO in the same case. Or he's actually been convicted of a RICO first and later gets charged with the predicate acts. All of those combinations have come in the federal courts. In every single instance, the federal courts have said Blockberger does not trigger double jeopardy here because a RICO case is a special kind of case. It's a particular kind of continuing offense, and that is particularly true in the context of a conspiracy. Nothing about any of these underlying offenses, you didn't hear any argument whatsoever that any of the previously convicted pled to offenses involved an enterprise of any kind, which this does, that they had to involve acts of racketeering activity, which this does, or that they involved a conspiratorial agreement, which this does. And so there is one conspiracy to murder charge, which was mentioned, but that's a different kind of conspiracy. And so the reason that you don't have double jeopardy here, and Blockberger is the controlling test, the Court of Appeals used it in an appeal out of the Atlanta Public Schools conviction very recently in a case called State versus Cotman, a RICO conspiracy conviction, and said no double jeopardy there, right? And it did the Blockberger analysis. And the point was the underlying offense is not an essential element of RICO because a RICO could be based on any one of 70 other types of underlying activity. The RICO, and expressly both Cotman and a prior case called Redford, Georgia has aligned itself with the federal cases to say that acts of racketeering activity are not lesser included offenses of RICO. And so you come down to the fact that they are just plain and simple different. And in fact, even in circumstances where defendants have been tried and acquitted for an underlying case, which of course can also try double jeopardy, that conduct can still be used as an act of racketeering activity or an overt act here. And the important thing, following up on what I've said about the structure of RICO and why it's different here, Your Honor, is that Mr. Arnold is not going to be separately convicted of the acts he's talking about. They are not freestanding counts. He will not be, if convicted, separately sentenced for those. So he will not be sentenced again or punished again in this. This is, in effect, evidence of how the RICO can be proved. Now, we have cited for you in our brief a series of cases as examples of this, which include
Give me just a moment. United States versus Link, 921 F. 2nd, 1523, an 11th Circuit case. In that case, prior convictions were introduced to prove the essential elements of a RICO conspiracy charge.
You said that was Blink?
Link,
Link.
L-I-N-K, as in a
Thank you,
chain.
sir. All right.
Yes. Did not violate double jeopardy. United States versus Caporale, C-A-P-O-R-A-L-E, 806 F. 2nd, 1487, 1986 case. Overt acts for which the defendant had previously been prosecuted were used, and to which he pled guilty, were used to prove the RICO conspiracy. Did not violate double jeopardy. U.S. v. Bolden, B-O-L-D-I-N, 772 F. 2nd, 719, 726 through 28, 11th Circuit, 1985. Prior convictions from 3 different cases were used to prove the RICO conspiracy in that case, held not a double jeopardy violation. All of these are under Blockberger. That's the test under Georgia law now. The idea, one of the difficulties here that's come up in this conceptually, the problem is it just doesn't fit RICO. And the 2021 case that was cited to you is not a RICO case. The Supreme Court case that doesn't deal with RICO at all. But the Georgia courts have said RICO is a particular kind of compound offense. This is not like a situation, say, where you have a DUI that results in a car crash and a death. And the solicitor takes the DUI, takes a plea to it. And then later on, the district attorney wants to charge vehicular homicide, where it's exactly the same act, exactly the same moment. In a RICO, there's more to it. There has to be more to it. Here, the defendants are charged with conspiring to obtain property through a pattern of racketeering activity and conspiring to conduct and participate in an enterprise through a pattern of racketeering activity. That enterprise being YSL. It's fundamentally different, and it's the thing that by its nature takes place over time. And so no one, literally no one in this country, in the context of RICO, has endorsed a rule that says that prosecutors have to bring the RICO as soon as they have 2 predicate acts, which is basically what you're being asked to do right here. And putting a hair trigger on RICO and hanging double jeopardy over it doesn't make any sense at all and isn't good for anybody. And there is no case in Georgia that has applied that rule here. There are cases federally, this exact argument wasn't contained in the briefing, so I haven't fleshed it out in our briefing. But there are cases at both the federal level and in other states that have looked at the same rule that basically say that wouldn't make any sense at all, because prosecutors would be given an instant use it or lose it rule on RICO, which would mean that in any circumstance in which we might have 2 acts, we would have to bring that charge. Your Honor, I've done this my entire career. I've written a book on this subject. I've literally read every state RICO decision there is in the United States. I don't know of one that endorses that approach. They all say that's a bad idea. On the flip side of it, when we look at the application of Blockberger and the cases that follow it, the authority is absolutely overwhelming. I mean, we cited a couple of cases for you on that collected cases from other jurisdictions. We cited several from the 11th Circuit. I didn't go past the 11th Circuit because it would be a footnote that would run to pages on the cases that have rejected these types of double jeopardy arguments. But again, I would point out that the fact that this is a conspiracy case really has a major impact on both the statute of limitations component, because we run off the last overt act by any defendant, so clearly within the time frame. And secondly, on the double jeopardy, we have cited to you case after case that has rejected these arguments under Blockberger. Both of the double jeopardy arguments that were made to you relied principally on Martin versus State. And the fact of the matter is, it just comes down to this. Martin has been dead and gone for 16 years. It is not the rule. And if you go back and read Martin, it is abundantly clear that had Blockberger been the rule, the result in Martin would have been the opposite of what it was. That is the result that it should be today.
All right. Thank you, Mr. Floyd.
Thank you, Your Honor.
Okay, all right. Ms. Merchant, any rebuttal?
Hey, respectfully.
Very briefly, Judge.
All right, go right ahead now.
Thank you. Judge, I wanted to respond. The state's began its argument that pattern of racketeering doesn't apply here. This is a conspiracy. They said it doesn't matter as long as there's an overt act, and that I'm basically reading the wrong parts of the statute. Judge, I tracked it based on their indictment and their language in the indictment. On page 12 of the indictment, when they actually allege the act that they're charging, they charge 16-14-4C. And they specifically state that my client conspired, well, they say a lot more than just conspired, but through a pattern of racketeering activity in violation of subsection A, which is the one that I quoted earlier, and, in the conjunctive, and while associated with an enterprise, did unlawfully conspire through a pattern of racketeering activity in violation of B. So they have charged him under this statute that I was citing to 16-14-4. They say the charge is C, and then they say that C is based on A and B. So if you go and you look at all of those, C says it's got to be a conspiracy to violate either A or B. Both A and B say that there's got to be an enterprise, a conspiracy, whatever you want to call it, through a pattern of racketeering activity. Then the definitions section 16-14-3 defines a pattern of racketeering activity. Subsection 4A, engaging at least 2 acts of racketeering activity. Why is this important? Because there's a big difference between predicate acts of racketeering activity, conspiring to commit those acts, which have to be a crime, and overt acts, which do not have to be a crime. They specifically charged him in the indictment under act number 11 with aggravated assault, which is in violation of an act of racketeering activity. And then they cited this definition section as to what racketeering activity, again, a crime. So overt acts are not necessarily crimes. Without predicate acts, overt acts don't get you there. So they need predicate acts. They need 2 or more predicate acts in order to get my client under the web of this case. And the 2 predicate acts that they're using, and again, as I said earlier, up until the May 9th stuff, which is different, and I'll address that in the bond motion, but the only way they get there is with these 2 predicate acts. So while before they re-indicted it, I asked for the entire indictment to be dismissed because I believe that was appropriate. Because without the 2 crimes that are both barred by double jeopardy, all they had was he posted a video on YouTube and he was in a picture on Instagram. So they had no crimes with my client. Now they've got him in a home on May 9th. So that's a different story. But we still believe that these 2 predicate acts should be barred from being used against him to show a pattern of racketeering activity. This is a broad statute. It's a very, very broad statute. But you have to prove something. And you have to prove that you did 2 crimes. And then you got to, for the pattern. That's how it's narrowly tailored to make sure that we're not just locking people up who are associated with criminals or alleged criminals or whatever it is. And the fact of the matter is the 2 crimes that he is charged with committing, he has already been sentenced for and pled guilty to. This DA's office has agreed to probation on those and misdemeanor on the other one. So those should not be able to be used against him, Judge. I wanted to go into the May 9th stuff for bond, but I assume you want me to wait on that.
What, in terms of your client for bond?
Yes.
Let me first button up this issue of your motions, and then I'll turn to the bond issue of bond. Mr. Floyd, anything else you want to respond as to?
Yes, and I'll be exceptionally brief. I mean, In this motion and in several others, the strategy of particular defendants is to try to turn the offense we charge into a different offense because they'd rather attack that one. The indictment is crystal clear. We charge a C violation. A C violation must involve a conspiracy to violate either A or B. It can involve a conspiracy to violate both. That was the APS case that was affirmed in the Cotton decision. Okay? The language is abundantly clear. Charging a conspiracy to violate A or B does not convert the charge into an A or B charge. Plain and simple, right? The language of C is perfectly clear. It does not mention a pattern of racketeering activity, right? And the pattern of racketeering activity does not become an element of C because the state is charged with violation of A or B. It's counsel is just simply wrong about that. I don't know how to make it any clearer. And we cited the Pasha case, which deals with conspiracy, which makes it clear that it is not necessary to prove acts of racketeering activity for conspiracy conviction. We can do that. We can put that evidence in. It is evidence of the conspiratorial agreement, but it is not an essential element. And that's simply where counsel's mistake.
Okay.
It is when they charge it like that. They charged it through a pattern of racketeering activity twice in the conjunctive on page 12. That's how they charged it.
Okay, I see it. All right. Okay. All right. Let me consider this, and then Ms. Merchant, I'll turn to your issue of bond. Okay.
Thank you, Judge.
All right. Okay, both of you filed quite extensive motions and law on this particular issue. Both issues, the motion to dismiss and on the based upon statute of limitations, as well as double jeopardy. And the courts had an opportunity to consider your pleadings as it pertains to both issues. And in particular, has had an opportunity to take a look at Maxwell versus the state 311 Georgia 673, as well as Martin versus the state Estevez, Hayes, and Drinkard, and Cotman. And Cotman is our Supreme Court's most recent pronouncement in regards to Rico and analysis, as well as gives the court some guidance in that respect. And Mr. Floyd, you did a fine job. I felt like I was back in law school again in terms of laying out the blockbuster test in our court's distinguishment of that along with the 11th Circuit's issue. So I'm in agreement with you about that in regards to how our court considers double jeopardy and Rico and conspiracy. And I have read that and do agree that Rico is a particular compound offense, takes place over time, and the aspects that are alleged at this point in time that you all have in your indictment that you'll of course have to prove, but that I'm going to, based upon what I've read so far, I'm going to deny the motion to dismiss and plea and bar based on statute of limitations, and also deny the motion to dismiss the indictment on double jeopardy grounds at this point in time. But they're well argued, well briefed, very interesting, and if I'm wrong, our appellate court, I'm sure, will tell me. So, Ms. Merchant, let's move to your bond hearing at this point in time.
Thank you so much, Judge.
And Mr. Floyd, I will leave you with the responsibility of preparing, or you and your team, a suitable order. Send that to Ms. Merchant, of course, for her perusal, and then I'll send that to Mr. Kearns, the court staff attorney, for my reading, and I'll edit, if any. Okay.
Will do.
All right, if you could do that by today is about a week from now, would that give you enough time?
Yes, sir.
Okay, all right. Okay, Ms. Burson, let's turn to bond at this point in time.
Great, thank you so much,
Yes.
Judge.
Mr. Smith, will we handle the motion for bond, Judge? May I step outside for a moment?
You may, sir.
Thank you, sir.
Oh shit.
Okay, madam, go
Great.
right ahead.
Thank you, Judge. Before I get into the main part of my argument, I want to let you know where my client will be living if he is released on bond.
Oh
I'm
shit.
not going to give the address publicly if that's okay with the court.
That is fine.
But I'll be happy to provide it. It's with his mother, who's actually outside the courtroom. He's got quite a bit of family members outside the courtroom. I guess they had an issue with having an ID and coming, but they're watching the public proceedings.
Do
right
they
now.
have, is the
The screen's on, so they're
Dawn
watching.
outside my courtroom?
It is, yes.
Okay, I
They've
just
all
wanna make
gathered
sure.
right there.
Okay, all right, want to make sure, okay. all right.
Yes, and they're hearing and seeing it fine. I just wanted to let you know that they were all here. Oh, there's his mother.
Okay.
They were all here. So it's clearly working. They heard me ask for her.
Okay.
But he went to Carver High School, Judge. His mom, the address that he would be living at, has lived there for 10 years with his grandmother. His sister is also in the area. Her name is Jaquita Arnold. She's a manager at a local Walmart. So he's got ties to the community, Judge. I think what the big issue for the state was originally in the court was his criminal history and these charges. And so I want to focus my argument on both of those. Judge, you've already heard our argument about the double jeopardy. So you know about the two prior crimes that are serving as the two predicate acts. But I want to talk about the other things that he's charged with here, just so that you understand fully, because, you know, it's hard. It's hard for me to separate when you lump a lot of things together. So I want to make sure that you understand what he's specifically charged with. Outside of those two predicate acts, the one that he received a reckless conduct plea for and one he received first offender, he's charged with an act of posing for a photo on a Mr. Garlington's Instagram account, and that is an overt act. He is charged with another overt act of appearing in a YouTube video where I believe it looks like somebody is rapping and he's on the video, a public YouTube video. Another overt act is that he posed for a photo on his Instagram account, and he had a shirt that said slime on it, and that's an overt act. Then he's charged with one other YouTube video where there's apparently some rapping going on, and he's in that. And then there's an overt act number 132. It says that he engaged in a conversation where Mr. Williams made some statements, but doesn't say anything about how Mr. Arnold participated in this. Just says that this was an overt act, that Mr. Williams made some statements during this conversation. Up until May 9th, that's the gist of what we had going on in this case. May 9th, when he was arrested on the grand jury warrant, they raided Mr. Williams' home. We were provided that discovery on Friday, and I was able to go through it, and it was very enlightening. My client is charged with several counts with that, but I think that the counts are somewhat disingenuous. In count 57, he is charged along with Mr. Kendrick and Mr. Williams with participation in a street gang for having marijuana, codeine, cocaine, and a firearm when the house was raided that day on May 9th. He's charged in number 58 with possessing marijuana with intent to distribute. Okay, so the street gang charge is based on all the individual charges. So I'm going to tell you about the individual charges. So marijuana with intent to distribute. Marijuana was found in a cabinet above the fridge, a kitchen cabinet. It was not in plain sight. It took the officers actually searching the home to find it. This is not Mr. Arnold's home. There were 20-something people that were taken outside, and on the videos, which I've arguably only gotten through about 8 of, on the videos, they knock on the door, SWAT raids the house, they take everybody outside, okay? So everybody's outside. Mr. Arnold's in a police car. Then they go in the house. The only thing they see when they go in the house, in plain view, they say, is a gun on a kitchen counter. There's no mention anywhere about where Mr. Arnold was in this house. This is a big house, where he was, if he was even in the kitchen. You come in my front door and you're in my dining room and my living room, you don't see my kitchen. You don't even go to my kitchen. Marijuana, 1,299 grams inside a kitchen cabinet above a refrigerator, closed. Officers didn't see it. Count 59, codeine with intent to distribute in a secret compartment. The police report says it was found in a secret compartment in Mr. Williams' home, not Mr. Arnold's home. Count 60, possession of cocaine. Again, secret compartment. Count 61, this is the firearm count. So there's quite a few they've lumped in the same count, so I'm going to walk through where all these guns were found because I think it's very relevant. The state indicted and told the grand jury that Mr. Arnold had on and within arm's reach a Glock 30S. That Glock 30S was actually found in a secret compartment in the pantry. They said that he had on and within arm's reach a Glock 357. That was actually found under a bed in someone's bedroom. They said he had a Glock 19. That was actually found inside a closed kitchen cabinet. They said he had a Smith & Wesson M&P, and he's also charged with that, because that's a machine gun, in count 62. They said he had within arm's reach or on his person, but yet that machine gun was found inside a kitchen cabinet. Finally, he's charged with a Glock 45. That Glock 45 was found downstairs. The only weapon that was in what could arguably even be called plain view in that home was an FN, which is registered to a Shazmeen Carroll. There were 20-something people at that house. You can hear, if you listen to the police talking, that the people that they felt they could arrest for the guns and drugs were either people on the grand jury warrant or convicted felons. My client's manager was there, and the cops are talking about how we need to run his history to see if he's a convicted felon so we can tag him with these things. The only reason he was charged was because he was present in a home that these items were found. There is absolutely no evidence he had a clue about any of these items. So these are all the new charges. You know what he did have on him? He had 3 grams of marijuana. That is 0.1 ounce. That is well below the legal limit. That's what Mr. Arnold had on him. So the state, I believe, will argue that all this supports that he's part of this criminal conspiracy and that he's a bad guy and shouldn't be released on bond. But the truth is, the same DA's office believed a few years ago that he should be on first offender probation. And he has successfully been on first offender probation. He has several marijuana arrests. He has been arrested. Every single one of them was dismissed, except for the ones I'm about to tell you about. In 2005, he had a forgery that he got PTI. It was dead docketed by Judge Schwall. In 2007, he completed 12 months of probation for a disorderly conduct. Successfully completed. Successfully appeared for court, successfully completed probation. In 2020, he successfully completed 12 months of probation for marijuana less than an ounce. In 2015, one of the cases that we talked about on the Predicate Act, he successfully completed probation for 12 months for a reckless conduct charge. All of the felonies were dismissed by the same prosecution. In 2016, the same prosecution agreed to first offender probation. So you can't say he committed new crimes while he was out on probation, because the crimes he's alleged to commit in the indictment are the crimes that he's on probation for. He has been successfully on probation, on first offender probation, where it is watched. He is watched, and he has not failed to appear. He hasn't failed to appear in court. He hasn't committed any new crimes, hasn't done any of that stuff. He's being charged with a crime he already committed. Well, arguably, in all fairness, he had 3 grams of marijuana on him on May 9th. So he did commit that crime, because that is still a crime in Georgia. So arguably, he did commit a misdemeanor of having marijuana on his person on May 9th when he was arrested. But that's it. He is not a convicted felon. He has significant ties to the community. We believe he is not a risk of flight, not a risk to intimidate. There's been no allegations that he's intimidated anybody. He's not part of that. whatever those allegations are. We're not privy to any of that. And so we don't believe that it's fair to lump him into that, because the case against Mr. Arnold is very, very weak. And leaving him in jail without a bond while he's waiting trial is unfairly punishing him for something that he is very likely not going to be found guilty of, Judge. And so we would just argue that he should be given bond. We'd ask for $50,000 or fine, house arrest, whatever satisfies the court's concerns for him. But he's not a risk, Judge. Thank you.
That was kind of fire, don't y'all think?
All right,
What y'all
Mr.
think,
Smith,
man?
let's say.
Good afternoon, Judge.
Uh-oh.
Judge, I would respectfully request that you deny the defense counsel's motion for bond at this time for the following reasons. I would submit to the court that Mr. Arnold, he's a documented YSL associate, Your Honor. He's demonstrated his commitment to the game, not only through the alleged offenses, but also through his prior convictions, Your Honor. As counsel has pointed out, Mr. Arnold has an extensive criminal history. His GCIC shows 17 cycles, and one of which even including a FTA from Fulton from 2016, I believe it is, Your Honor. I would submit to the court that the defendant, he poses a risk of committing additional felonies pending trial. As counsel pointed, the defendant was indicted and he was charged with only one count of racketeering. Following his arrest, as counsel also pointed out, he was charged and subsequently indicted with 6 additional felonies. Those are counts 57 through 62 of the current re-indictment, Your Honor. Those charges, those additional felonies involve possession of drugs, and possession of firearm, and possession of a machine gun. But counsel didn't point out that those are distribution amounts of drugs that he was possessing.
What the 3 grams of marijuana? What is that? That's what was found on him, right?
That was found on him, but within the home there were distribution amounts of marijuana as well as.
That's Mr. Williams' home, right?
That's correct.
Okay.
Mr. Arnold was not just merely present in the home, Your Honor. He had a bag that belonged to him within the home. And at the time of when officers were attempting to search the home, well, when they came and knocked on the door, it took them a while to answer the door, Your Honor. They could have hidden the drugs and everything at that particular time, Your Honor. He was also charged with possession of a machine gun. That was the Glock 45. I think counsel inappropriately or incorrectly indicated that the MP was a machine gun. It was actually the Glock 45 that was a machine gun. Your Honor, based on the facts and circumstances.
Was that on him or was that found in the home?
That was found within the home, Your Honor.
Was it within his arm's reach or?
If I'm not mistaken, I believe it was within the common area.
What county you refer? What county?
Common area.
What county is that, sir?
That,
62.
62.
Sorry, 62.
2.
Or it's count 63 if you're looking at counts.
My client's not charged with that. Count 63 is not my client.
Oh, I'm sorry, that's count 62 then.
Yep.
That's what Mr. Arnold.
Okay, so tell me about the circumstances about 62, count 62. Was that the arrest for the Mr. Williams' home or what?
Yes, that is the arrest of Mr. Williams' home, Judge.
Okay, was he found with his firearm on him, or was it within arm's reach, or was it in the home?
If I'm not mistaken, it was within the home, within arm's reach.
Judge, it was downstairs. It's in the police report.
That boy lying.
Is that true, Mr. Smith?
One second.
While it may have been found downstairs, Your Honor, it was obvious and it was open. It wasn't hidden or anything like that. It was in the open area. It was obvious.
Okay. Okay, so he's still on probation for a first offender, is that correct?
That is correct, Your Honor.
And he was sentenced on that case when?
In 2015, I believe it is.
Okay, 2015.
Yes.
Are you still on probation for that?
That's the first offender probation. Correct, Your Honor.
Is there a revocation that's pending on that?
No revocations to my knowledge at this time, Your Honor.
Who is that case with at this point in time? Which one of my colleagues, or is that with me?
Yes.
Hold on 1 second.
The 2015 case.
This nigga lying, dog. Uh-oh. It's looking shaky, y'all. Make sure y'all smash that like button, by the way. Looking type shaky.
Well, the first offender probation, Judge, that one is sealed. So I'm not.
Did he complete it?
No, he's currently in process of it now.
That means he's still on probation.
Correct.
Who has that case, and how much more time is he on probation?
Judge, he's not. I believe it was Judge Adams, and he successfully completed that probation. That's why it's sealed.
Okay, so he's finished that particular period of probation that he was sentenced on in 2014. Is that correct?
It was 2016, Judge.
2016?
Yes, and he has successfully completed that probation, Judge, and that is the predicate act in count. The one.
56.
Yeah, that's one of the ones that I was arguing earlier.
Okay, all right.
Yeah.
So there was no revocation. It was the same offense, but so it wouldn't have been like subsequent to probation, but he's not even on it. So.
May I continue, Judge?
Yes, you may, sir. Absolutely.
Thank you, Judge. Thank you. I would represent to the court that based on the facts and circumstances of this case, he poses a risk to the community and intimidating witnesses, Judge. At first appearance, Judge Wood denied bond, citing basically that he was at risk to commit additional felonies as his basis for denial. May 23rd, this court denied bond, citing all the Ayala factors as its basis for denial. There has been no change in circumstances, Judge. And I would respectfully request that you deny defense counsel's motion for bond and the defendant remain in custody of the Fulton County Sheriff's Department.
So you specifically say he's a risk to the community. Any other things that?
And a risk of intimidating witnesses, as well as a risk of committing additional felonies.
Has he contacted anybody since this indictment in jail, or are they in any other location?
Not to my knowledge, Judge.
You don't look confident, champ. Respectfully, you're gonna have to get right. This nigga trash. They should have let my son King Slime up there. Hey, first of all, Karen is bugging on these niggas. Respectfully, I can't hold you. She's kind of wilding on these niggas. You dig? Karen is really wilding. Can't hold you. Judge might get that bond, but he might not. Nah, they gotta let King Slime up there. He know what he doing. Nigga fumbling a bunch of papers with no words on them at this point in time.
Judge, may I add just two things briefly?
You certainly may, go right
Thank you,
ahead.
Judge. So in Act 11 that council points out, I just want to briefly give you some background as to the allegations in that, the facts in that particular case. He was actually shooting in public in daylight at the victim in that particular case. I believe, if I'm not mistaken, that was at Lenox Mall.
You said it's count 11?
Yeah, not count 11, Act 11 of count 1.
Is it Act 11?
Act 11. And
Okay.
then combined in Act 56, some of the background of that conspiracy to commit murder and that gang charge. He was actually apprehended in rival gang territory in the process of going to
this nigga freestyling,
commit murder in retaliation for a shooting against a rival gang member, Judge. And for those reasons, I would respectfully request that you deny defense counsel's motion for bond.
that nigga nervous.
Okay. Ms. Mercer, you want to address that? I'll give you one more opportunity to address that issue. You know, the state's basically saying he's a danger to the community. I mean, because what's proffered, not proven, but proffered at this point in time is in count 11, there's some fairly serious conduct as well as predicate act 11, I should say, and predicate act 56, which involve use of weapons. So you want to address that?
I do, definitely, Judge. Judge, this same prosecution office dismissed the aggravated assault with a deadly weapon in count 11. They null-prossed it back in 2015. I believe it was February 2015. That's in case 14 SC 131032. So I know that now they're arguing that it was serious and he was dangerous, but they dismissed it. And
that could be for any number of
it
reasons.
could be, but they agreed to a reckless conduct plea of guilty. And then subsequent to that, they offered him first offender probation. So if they dismissed it because the evidence was weak or whatever, then they also gave him first offender probation just a year later. So one would think that if he was such a threat to the community and so dangerous that he would not then get first offender probation less than a year later.
Well, that's the court's decision. Of course, the state gets an opportunity to weigh in. So does your client. So does your, the accused, as long as they're not statutorily prohibited, meaning they haven't taken first offender some other place, location, basically anywhere in the world. Then the court can, depending upon the facts, determine whether they want to take a first offender sentence.
I'm glad you pointed that out, Judge, because it's even better. The judge found that he was eligible for probation and sentenced him to probation and found that that was appropriate. So he was an appropriate candidate for probation. If you are a danger to commit felonies or intimidate people or, wreak havoc on the community, a judge and the district attorney both were in agreement that he should receive probation after this 2015 case. So the 2015 case that serves as Act 11, which they're saying, shows that he's this dangerous person, he gets a guilty reckless conduct in that. So then we move on, and in 2015 he's arrested and he takes a plea in 2016 to the first offender. He's given 5 years probation and successfully completes it. So everybody was in agreement after all these acts had happened that he is a great candidate, and he was a great candidate for probation. He did exactly what probation is designed to do. He successfully completed it without any infractions. The judge, one thing I did want to just mention, the state said he had an FTA in 2016. A quick check of the clerk's file will show that that was dismissed because he was not sent notice. So it was actually set aside. So that was not his fault. And I don't believe that that should be used against him since it was not his problem. And it was not his fault that he was not sent notice. It was quickly set aside. And that is the case that he received first offender on. So I just wanted to make sure that was cleared up. The court had some questions about the guns and where the guns were found. Again, there was nothing found on him other than these 3 grams, which is 0.1 ounce of marijuana. Thank you.
Okay.
Judge, may I get brief for this time?
Just give me a second, sir.
Yes, sir.
Do you have any other motions, Madam, at this point in time, Ms. Merchant?
No, Judge, thank you.
Okay, all right. Mr. Smith,
Thank you, Judge.
make it brief.
Very brief. As I mentioned previously, he continues to demonstrate his commitment to the game. Guns in 2014, guns in 2015, he continues to show that he's constantly involved in this dangerous activity. I would ask that you affirm the magistrate's court's decision that he's a risk to commit additional felony, and reaffirm your decision, Judge. Thank you.
All right, I'm gonna just take a few minutes. I need to take a comfort break, and I'll come back and I'll give you my decision at that point in time, okay?
Thank you,
We're
Judge.
in recess.
All right, y'all. Make sure y'all smash that like button. Let me explain something to y'all, man. Why in the world are you weird people coming in the chat trying to sexualize everything, man? Somebody came in the chat saying, Karen looking thick. But how would you know she was thick, champ? Respectfully. Can't nobody really see Shorty's body like that. Number two, is that the first thing you think about when you watching this, champ? I must keep it in the G, champ. You gotta be one horny bastard to assume that somebody's thick and you can't see, champ. We gotta do better. We have to do better, champ. Respectfully. You feel me? Niggas don't even see. Like, what's going on, man? Oh, Karen is thick. God damn. Well, we can't see, champ. I don't see no buns on the screen, but for some reason, somebody imaginarily just seen buns in their head of Karen. For some reason, you got X-ray vision, gang. Well, I'm here to tell you you don't. Oh, this chick is hideous. Oh, God. Woo! That's one ugly bitch, champ. Good God. We want to talk about somebody looking hit. Jesus Christ. I bet you gonna say she thick too now, ain't you, champ, huh? That's thick? You see, that's thick too, huh? I bet that's thick. Yeah. Okay. Not so thick now. I ain't think so, champ. Yeah, champ. This is insane. Niggas is out of pocket once again. Typical though. This is nasty work. I see what's going on here. Oh man. Yeah, that was nasty work. You know what I'm saying? When you got a prosecution that look like that, I'll be very worried. They gonna make sure somebody that look like that is gonna make sure that you don't come home, nigga. Somebody that look like that gonna make sure you don't come home. Yeah, niggas is out of pocket. Boy, oh boy. I ain't gonna hold y'all, man. The dude, man, whoever that prosecutor is, the black dude was fumbling bad, bro. He got some really, like, he was just terrible, man. You know, Karen was on point, but son, your boy Farnsworth Bentley was trash, nigga. He really looked like Jesse Smollett, whatever his name is, nigga. And Farnsworth Bentley together as one. And all I'm trying to say here is that nigga was trash, and I would hate for him to ever represent somebody. You did? Very much out of pocket. Your boy Farnsworth was trash. That nigga was reading blank pages with no words on them. Said, you know what, Your Honor? I think he did violate probation. It says here, section blank, that, yeah, this happened. You know what I mean? Yeah. Okay. Okay, bet. Sounds good, champ. Now, a lot of people believe that the judge don't give a damn what Karen is talking about. He still is not granting anybody bond. Allegedly. We gonna see what it's hitting for though. mm, mm, mm. Boy, oh boy. I mean, do y'all believe that there's gonna be possible bond because Karen gave a very good, testimony? What y'all think? I mean, I don't know, honestly. I really don't know about that this time. But yeah, man. We gonna see what it's hitting for, man. We gonna see what it's hitting for. I would be a little bit surprised, but who knows, bro? A lot of people believe that if it happened in the past, then it automatically just goes nowhere. But that's not true. Usually, they hitting you with old charges and all that. They hitting you with old charges, but just because they hit you with old charges doesn't guarantee that you know you gonna make bond, because those old charges, they gonna use it. It do look like it's a possibility that Son might make bond though, because like I said, them past charges, they still gonna try to get you for them past charges, bro. Respectfully, that's what happens sometimes. This judge, it don't look like these judges playing any type of games. And I think it's all everything always goes down to the judge anyway. It don't matter how good the testimony was. The judge is gonna do whatever he want to do. Period. He got the final say in the matter. The judge is gonna do whatever he see fit in his mind to do, whether or not, you know what I'm saying, it was a good testimony or not. That's just how it is, man.
Where the Chick-fil-A was, right?
That's in government.
No, they had a mini Chick-fil-A.
Oh, really?
In the cafeteria.
Yeah, that's since COVID. Oh, okay.
So now
I was like, they had that after the health department.
So now the only thing in the courthouse are those vending machines?
In the government center, they have, better, they have like a little, tiny marketing store, but you have to go through security to get there.
And is there anything, and the other thing that's awful is during COVID, Big Daddy's Club went out of business.
Yes.
And so now
Yeah, there's no food.
how far away from where do you eat?
Where do you go eat?
Where do you eat? Where'd you eat lunch there?
Yeah, you don't
They gave me a.
Y'all hear this conversation?
There's every smart enough to you have banana and.
Where did you all eat today?
At my desk.
They gave a bag lunch, right? They
Yeah,
never
it
had any
starts
bag
down
lunch.
there, there's nowhere.
Big Daddy's Club.
We used to go to the sandwich shop.
You can eat it. Yeah, down in the basement, they've got a huge.
We used to have those sandwich
Where did you guys have lunch? Like, oh man. Niggas dead ass talking about food, bro. Hey, this is what they do, champ. They definitely don't know that they being recorded.
It was a gator farm, like there's a couple places.
See, when it comes to so we weren't cocky like you guys.
And now it's all fine. We're good.
I was a gator farmer. That's all I was a gator farmer. And I was gonna stick a gator. And then I started I moved to Bowling Beach.
I know.
Florida. You were 8 years. In 1982. And we beat Florida 43-17. But no, I graduated this summer. I went to work for USC in Alabama. And they're like, pick a team. I'm like, well, I have a team. They're like, no, pick a team. I'm like, okay, Alabama.
Oh,
That's my
no.
very surreal. My family's from Baltimore County.
Make sure y'all smashing that like. If you're new to the channel, subscribe to the channel. We got a lot of content dropping today. I'm not gonna hold you.
Once in a while. How's that woman walking? Try. You know, I know a lot of hospitals. They really do. You know? He could because he had oral, right? Back to back. Reordered the trial. What was it? He's a good prosecutor. He's a good prosecutor. I don't know. Well, that, you know, was true Mr. Howard too. Mr. Howard tried to come in.
I think I told y'all about spamming, didn't I?
If you're gonna eat
Hey, look, champ, respectfully. If you want attention, I suggest you go somewhere else with that. I don't get the point of spamming fire out the chat because you want my attention.
On Henny or on Andrew?
On hand.
On Henny.
And then so we were gonna do that together. So I went to Cobb.
We went to Cobb.
When Vic got elected.
Right.
And he told.
Well, the reason Robert lost that election was a lot of reasons. One was the demographics. Two was
Eric Martinez, where you at?
Sorry, I had wait, I think Henry is a little long.
Right now, we waiting for the judge to come back to see whether he grants bond or not. And this is not for Young Thug, by the way. I believe this is for Gunna.
Not only that, but he used to like
I believe. You know what I'm saying? Eric Martinez, what's your screen name, bro?
I can see. I'm just saying. I can see him really loving you from his reactions to me because I think we look pretty similar. But anyway.
Sure.
Is this bitch in the back talking about a threesome? Or maybe I'm wilding.
I mean, one time, I remember one time. I had right. I'm allergic to bees. So I was in a big section here in York. I had gotten stuck. I didn't make it big, so I got rushed to the hospital, like literally.
Damn, shorty, you got stung by a bee.
So many steroid shots in my passion. So I'm sitting there, literally, like this in this courtroom. And it was all steroids, all this makes you so sick. So I about 2 or 3 in the afternoon, I physically agreed, sitting at comfortable. And he calls me up to his desk, and then he's like, so are you okay? And I'm like, well, Judge, I'm a little sick to my stomach because, you know, just extenuating circumstance with being home from drug last night. He brought me like in chambers. Oh, I wasn't actually, I didn't care, I ate it. I was like, I'm shocked. I can't even tell you. Well, I mean, I worked in Congress, and I was a law recruiter for Georgia, so you get a prize if you surprise me.
Oh, that's you, Brown? Copy. I see you, Chin. Hold on. Why you not telling me, hold on, man.
So anyway, it's a long shot.
Who boomed on you? Can you at least tell me what your YouTube screen name is? Because I don't see you, gang, respectfully.
It's like that I might get offended. If you reached out like under my breath, like then I might like punch my face. But short of that.
Well, that's you, Copy. I see you, bro. Oh, you lying? Nah, bro. You gotta be put on timeout. You're wild. Yeah.
Oh, no, please be seated. Thank you for your patience.
Uh-oh. Let's get right.
Okay, the court's had an opportunity to ponder, take a comfort break as well, but ponder the issues in relation to bond in terms of Mr. Martinez Arnold in indictment ending 572. And I have considered under the bond statute 17-6-1. Of course, the purpose of pretrial bonds prevent punishment for conviction, secure the appearance of the person in court for trial, and that the trial court can release a person on bail if I find that 1, they pose no significant risk of flight from the jurisdiction of the court or failing to appear in the court when required, pose no significant threat or danger to any person, community, or property in the community. 3, pose no significant risk of committing additional felonies pending trial. And 4, pose no significant risk of intimidating witnesses or otherwise obstructing the administration of justice. And the appellate courts, of course, require the trial court to explain any reason for denying bond and that the denial of bond is not be set aside unless there's a manifest or flagrant abuse of discretion. That's all fairly contained in Ayala versus the state 262 Georgia bond case in Georgia. Having considered all of the arguments of counsel and the proffers that have been made thus far, the court is of the opinion that Mr. Arnold still poses significant threats to persons and property in the community. In particular, and for that reason, and as well as poses significant risk of intimidation of witnesses and otherwise obstruction of justice. So I'm going to deny bond.
Oh, Lil Duke is still in, champ. Oh man.
However, Ms. Merchant, if you should have a change in circumstances or any other conditions are brought to the court, I'll of course reconsider bond accordingly. Okay.
Great, thank you, Judge.
All right. Okay, all right.
Little Duke is still in there.
Madam, you are welcome to stay. I've still got some other matters I need to take up, Ms. Merchant, but you and your client are welcome to remain on the Zoom call as well as the in court.
It's crazy.
Okay,
Little
all right.
Duke ain't really do shit.
All
That's
right.
the crazy part.
Mr. App, sorry that it's taken me so long to get back to you, but as you can see, I've had a lot of things to deal with today, so I appreciate your patience.
Yikes.
Let me first find Mr. Kendrick if he is on the platform. Mr. Kendrick?
Man, this is nasty work. I ain't gonna hold you.
Mr. Kendrick, if you're on our platform, please raise your hand. Okay, Mr. Kendrick, you are an N506 at this point in time. All right.
And as I said before, but I'll reiterate to the court, Judge, we're always here at the court's pleasure. So we appreciate the court saying that we've been patient, but we're here for court anytime the court wants or needs us.
All right. And I appreciate you saying that, Mr. App. What I'm going to do is, okay, first, you have I've enumerated your motions that you have pending at this point in time. Do you still wish to have your motion to sever, or is that something that you wish to table for the time being?
So, and I mean, again, I said it before, but I'll also reiterate what I said, another comment I made earlier. I mean, no disrespect to the state. I have tremendous respect for Mr. Gary and Mr. Floyd and Mr. Smith and Ms. Rosenwasser, who is here as well, and their team. I respect them professionally. I do. However, they filed lengthy briefs in response to our motions. Yesterday, they filed those responses.
Do you want some time to ponder those?
That doesn't give us a lot of time. And
I don't mind it. I mean, look, that's why I asked you. I mean, it's not a thing that I need to necessarily need to spend. If you want some more time to look at and consider that, then I'll go ahead and put that, afford you that opportunity to do so.
Yes, please.
Would you like to defer on all of your motions, or just the motion to sever at this point in time?
I think we're going to defer on all of them. I do want to make sure that the court sort of listed our motions earlier today, but just so the court is clear and the state is aware, I'm going to argue the motion to sever, and I'm going to also argue the special demurrer. My co-counsel, Ms. Hingerty, will be arguing the general demurrer, and my co-counsel, Mr. Weinstein, will be arguing the motion to strike.
Can you spell Ms. Hingerty's name just for the record, please?
Hingerty.
All right, thank you.
First name is Katie, Katie.
Hingerty?
Hingerty.
Okay, got it. Okay. All right. Okay, not a problem. We can certainly defer that. I think that given where your client is located at the Fulton County Jail, that Mr. Chamberlain indicated that would probably be the 13th of October. So we'll carry that until that time, sir.
We will be here. In my understanding is the court is going to issue a written order on the discovery issues that were decided earlier today.
Well, I'm going to have the state draft that, and I will consider it. But they will certainly send you all pursuant to their responsibilities as advocates for you all to look at before I enter it.
And then
have a copy of that in the sometime tomorrow.
And then also, Your Honor, just so I am clear, the other motions the state has filed, there were multiple motions the state filed on juror issues. Those are all being tabled for now.
That is correct. The state has a couple of motions related to jurors, and that is their identity, the note-taking and consideration of evidence, and the addressing juror selection and strikes. I'm tabling those for the time being till a little closer to trial. The only one that I am going to go ahead and get you all collectively as a group working is that the court was going to go ahead and do a questionnaire to assist the court with jury selection. So since the state referenced that they were going to do that, I'm going to go ahead and grant that so that can start to percolate amongst all of you.
And just again, so should I be prepared? Should I and the other counsel for Mr. Kendrick be prepared to argue any of the other juror motions the state has filed on October 13th?
No.
Okay.
Not on the 13th. No.
And I think a juror questionnaire is wise. I vaguely remember trying a lengthy murder case in your courtroom where there were problems and we had a mistrial because the jury sent out a note saying that they were scared and didn't want to hear the trial. And so a juror questionnaire hopefully will alleviate some of those types of concerns.
Sir.
You want us to prepare an order on the questionnaire?
Yes.
Would you like a date certain as to when those are due to?
I'm open to suggestions.
I was just, whatever the last day of the month is, that gives us basically 2.5 weeks to come up with a questionnaire.
You want to say the end of October?
Oh, I was gonna say September to give you time. Here's what I'm looking at, Judge. We've got 4 months from tomorrow. I figured if you got it within a month, and then you could work on it, come out with a final, they're probably gonna be sending out notices to this many jurors about 2 months beforehand. So that gives us a month to do it and a month for you.
I would say that's correct. All right. So yes, by 30 September.
Whatever the last work day is of this month, Judge, we can say it's due to you by COB that day.
That would be the 30th of September.
Yes, sir.
Yeah, that's fine.
Do you
We'll
want?
have you tomorrow, Judge, or we'll send copies to the court too.
Yes.
Do you want the defense to prepare questions on the juror
Yes.
questionnaire?
That's usually how it works, Mr.
Yeah,
Okay, I mean, look, it's going to be sent. You have questions you want me to add in, certainly, send them, and I'll, before it's actually kind of final, I'll of course entertain any arguments or anything as to what I will and won't add, what I will include and what I won't include.
By September 30th.
No, the questions are to be submitted
by September 30th.
Yes,
I understand.
And then I'll start working on the compendium.
Got it.
And then at a date certain, I'll tell you all, hey, come on in and let's discuss what I'm going to give and what I'm not going to give.
Thank you, Your Honor.
And Your Honor, for
And now identify yourself.
I'm sorry, Katie Hingerty here for Mr. Diamante.
Thank you.
I apologize, Judge.
Okay.
Just for clarification, on October the 13th, is that a 9 a.m. court date here in person?
Unless I tell you otherwise, yes, ma'am.
Judge.
Then that is all our business, Your Honor.
Okay. All right. Thank you all. And what I'll do is then I'll table those to the 13th of October at 9 a.m. and we'll adjust accordingly. So, Mr. Kendrick.
Yes, sir.
The lawyers will be back in touch with you. Okay. And we'll see you on the 13th of October. Okay.
Yes, sir.
All right. Thank you, sir. I'm going to release you at this point.
All right. Have a nice day.
All right. Thank you. Same. All right. Does anybody else have any other business before me? Mr.
Yes, Your Honor.
Yes, Mr. Matthews.
Good afternoon, Judge. Carson Matthews here again on Marquavius Huey.
Yes, sir. Given the discovery in this case, do you want me to hold you have a motion to sever, motion to suppress, and a general motion to suppress, and a motion to suppress the defendant's statement.
That is correct. And you hit the nail on the head, Your Honor. I'm asking you to hold on our motions. In fact, I was under the impression today that we were only going to be hearing the bond hearing. That's what I was actually noticed on. So I do want to hold until I can get all of the discovery so I can determine which motions are applicable to this case and which are not.
I'm going to put your motions back on for the 13th since your client, where's Mr. Hughes? Let's see. Mr. Hughes, since he's in the Fulton County Jail, I'm going to put him back on for 13 October. That is when I have the next available Zoom accessibility. So I'll go ahead and put him on for that date, and you can let me know. I'll notice those motions, and if you wish to still proceed with them at that point in time, then you can let me know, okay?
Yes, Your Honor, and I have one last question for the court. Is there a case management scheduling order of sorts that we are moving under on this particular case?
No, not yet.
Oh, okay. All right. Thank you, Judge.
Okay. All right. Anything else, sir?
That's all I've got.
All right. Unless you have anything else, then you may be excused at this point in time. Okay.
Okay.
All right. Thank you, sir. Thank you for your patience.
You got it.
All right. Anybody else on the platform I've not otherwise addressed have any other questions they wish to ask the court? Okay. If not, then some of you will be back before us on the 5th or the 13th of October. And we will send notices appropriate to everyone, notifying them of those dates. All are welcome to participate and listen in, even if you don't have any motions directly on that date. Okay? Mr. Geary, anything else?
No, sir.
Okay, all right, we're in recess then.
All right, sir. Thank you, sir.
All right, thank you. Okay, all right.
Whoa.
You should have those two motions. We'll send them out to defense counsel.
We out of here, champs. Make sure you smash the like button and subscribe to the channel. We out of here. Peace.